Welcome to the
Muted.
video conference, Reopening the Economy, the Challenges Businesses Should Encounter. I apologize for any technical difficulties. If I could ask anybody who is a speaker to mute their line now, that would be great. Thank you. My name is Albert Lee. I'm an attorney at the law firm of Tucker Ahrensberg, where I co-chair the firm's labor and employment practice group. I have the pleasure of being here today with James Fawcett, Vice President, First National Insurance Agency, Will Collins, Client Advisor, First National Insurance Agency, Tom Cray, shareholder of the accounting firm Holsinger, and Andy Bianco, also a shareholder of Holsinger. On behalf of all of us at Tucker Ahrensberg, First National Insurance Agency, and Holsinger, we thank you very much for joining us today as we share legal, accounting, and insurance-related information that businesses and organizations should know as we start reopening the economy. Before we get started, I would like to acknowledge that these are extraordinary times, and we hope all of you and your families are safe and doing well. I also want to go over a few items regarding today's event. This is an audio-only conference. There is a PowerPoint slide deck that was sent to registrants this morning. If for some reason you did not receive it, please email Allison Hurley. I'll give you her address. It's A Hurley, AHURLEY at tuckerlaw.com, TUCKERLAW.com, and she will forward it to you. You also have the opportunity to submit text questions to today's presenters by sending your questions to Allison. Again, her email address is ahurley at tuckerlaw.com. You may send your questions in to her at any time during the presentation. We'll collect them and address as many as possible during the Q&A session at the end of today's presentation. Today's audio conference is being recorded. You'll be able to get a link within 24 to 48 hours of the recording by email. If you wish to follow up with any of the presenters, their contact information is included in the PowerPoint deck. And lastly, it's important that I issue this disclaimer. This program is for general informational purposes only. This content neither constitutes nor substitutes for legal, tax, accounting, or other professional advice that takes into account your or your organization's specific circumstances, legal jurisdictions, or regulatory concerns. The views expressed today are those of each speaker, not necessarily those of Tucker Ahrensberg, Holsinger, or First National Insurance Agency / FNB, which do not make any endorsement, recommendation, or warranty express or implied regarding the content of this program, and any legal liability or responsibility for the accuracy, completeness, or usefulness of any information, product, service, or process presented today is disclaimed. I would now like to introduce co-presenter James Fawcett of First National Insurance Agency. Jim?
Hey, good morning, Albert. Thank you so much for the warm introduction. And good morning to everybody on the call. Over 400 registered, so we're excited to be covering such a large platform of attendees. I'm just going to go over a couple items. I specialize in the Employee Benefits Division for First National Insurance. So I want to focus on what COVID-19 is impacting from a health insurance standpoint, from the claims, from self-insured and fully insured. So 3 quick slides, but hopefully helpful for you to kind of see where this pandemic is taking us from a healthcare standpoint. So it's really interesting. On the first slide, the impact of claims from a utilization standpoint. Clearly, we're seeing an increase in testings, emergency room visit, doctor office visit for COVID-19 type symptoms. Should you have those kind of symptoms, respiratory issues, things of that nature, longer hospital admissions just to play it safe. If somebody tests positive for COVID-19 and they are unfortunately not able to simply self-quarantine, it's an almost immediate admission to the ICU, to the intensive care unit, which is extremely expensive. So we are seeing an increase there, though the percentages are small, as we know. We're seeing big decreases in non-essential medical procedures. Your urgent care trips are now turning into telemedicine. The frivolous emergency room visits are non-existent. Elective surgeries have been delayed. right? There, in the month of April, there are basically no knee replacements going on or shoulder surgery, things of that nature. We're seeing treatment avoidance for self-referred and minor and routine care. So it's a very interesting dynamic between the increase in COVID-related claims, but the decrease in non-essential, which makes up a massive portion of healthcare expense. The avoided claims, it's a combination of self-referred care for minor illnesses that would have led to inpatient, outpatient, professional or prescription drug usage. Ultimately, though, we see the majority of these claims coming back, right? Delayed claims, where the months of March, April, and May, they've been postponed. We are seeing a catch-up by November for these claims. So by the month of November, the claims that were avoided in March, April, May should probably get you about whole there. So what does this mean if I'm a self-insured employer? So I'm going to go to slide 2 now. On slide 2, we did an analysis on over 50 self-funded groups, and 85% of them came back with this. So we're pretty confident in the results. But for every one of our self-insured clients, the first thing we do is we on an annual basis, we budget, right? We set the budget of their baseline claims. What is our projection of what your claims are going to be this year? So then what we do, or what we've seen, is the claims that have been avoided or delayed, that's the impact of the March, April, May, and then we subtract those out. Then we add in the COVID-19 claims and technically add in back the delayed claims for the November rush, and that equals the new adjusted claims. So if you take this formula, basically, here's where we budgeted you. These are the claims that didn't happen and won't happen. These are the claims that didn't happen but will come back. And then we need to add in the COVID claims. We're actually seeing a reduction of about 3% over a 12-month period. And again, we've done this metric over 50 self-insured groups. 85% of them came with this result on average of a reduction in claims of about 3%. And if you think about it, we basically didn't use healthcare for a month and a half. Now, again, a lot are coming back, but we are seeing about a reduction of 3% on the claim spend. So just thought that was interesting. And for those who have a self-insured plan, this is what we're pretty confident in seeing the results on an average. So if you're a fully insured company, meaning you purchase insurance in lieu of paying the claims, we're seeing something a little bit different. A lot of the carriers are actually changing or adjusting their base experience period. What is a base experience period? It's your renewal snapshot. It's the time frame that they calculate your claims and premium to generate your renewal. It's typically done anywhere from 4 months, 6 months, even sometimes 12 months prior to the effective date. But why are they doing that? So here are the two thought processes as to why we think carriers are doing this. One, avoid the month of April in total. Throw that month out. It did not count. It was unrealistic. There wasn't many claims in that month compared to the average, so we're not even going to put that into the calculation. Or two, we want to make sure we include the month of April, because though the claims didn't appear, we need to apply a rating factor and capture the claims that should have happened, and also be aware to estimate the potential COVID-19 claims that we're going to build in. So it is very interesting. We're not 100% sure where these carriers are going. I'm not going to give my opinion, but that being said, the fully insured carriers have an opportunity to take the month of April and apply a different factor to it. So that's what we're seeing from a renewal calc standpoint or calculation standpoint. But so what does this mean for my carriers from a short-term renewal forecast? And define short-term as the next year. By this time, July 21. What are we seeing in the marketplace from a fully insured? I've broken it out basically into two sectors. The one sector of carrier is the carrier that has a relationship with a health system. We call that an integrated delivery system, where there is a health system and a health insurance carrier married together. Or there's a formal relationship with a health system. So if you think about it, the hospitals right now, the capacity of patients is at an all-time low because of the elective care not happening, and also just people not wanting to go to the hospital. So the hospital care right now is at an all-time low, which translates to millions and millions of lost revenue dollars. So when they have their sister company, their parent company, and they say, hey, we need help subsidized, dear insurance company, please help fund us. So then the insurance company most likely is obligated to fund or help offset dollars for the healthcare system, which then translates to, well, if I have to give the healthcare system money, I need to get more money from my clientele, from my customers. So we are anticipating higher than usual. I'm not saying out of this world, but higher than usual trend increases for the next year for integrated delivery system carriers. In your prospective markets, you probably know who I'm talking about. On the flip side, though, what is interesting is we do foresee an opportunity for the national carriers to gain more market share. These national carriers don't have a health system that needs to be subsidized. So in their eyes, and what they're experiencing, which is kind of interesting, is employers, for the most part, paid the same amount of premium in April for their health care, yet healthcare costs went significantly down. So I basically got a free claim month. I made a lot of money off of my client, off of our customer base. We had a good year. We can be more competitive on the renewal, competitive on the RFP process for new business. So we are foreseeing that if you're in a market that has a regional player, a regional carrier, or integrated delivery systems, we're anticipating a little bit of a hard market coming in the next 12 months, where we are also foreseeing the national carriers coming in with a little bit more of a competitive edge to them to try to obtain market share. In my opinion, more market competition, the better, right? It can help control healthcare costs in the fully insured realm. So we're seeing increases in claims from COVID related, but the big thing is we're seeing a lot of decrease in claims because of no one's getting the elective procedures or the frivolous usage. It's going to blend to about a 3% increase, or excuse me, 3% decrease in claims overall, which is nice to hear. On the self-insured side, I would anticipate status quo from a reinsurance standpoint. The fully insured side, we're going to go through a little bit of a roller coaster here, depending on the carrier you're with. And we're foreseeing this for the next 12 months as we enter the quote-unquote new norm. So I want to thank everybody for your time. Thank you for registering and participating. Hope everyone stays safe. To all those in the counties of Pennsylvania, happy Yellow Day. Their first day at Yellow. So to all, thank you so much for the opportunity to speak. And Albert, I'll flip it back to you.
Thanks, Jim. This is Albert Lee. Again, I'm a labor and employment lawyer, so my issue today is talking about the employment stuff. It comes with reopening the workplace. Most states have taken steps to reopen their economies. As Jim just mentioned, Pennsylvania has already taken a step last week and is taking one today into what it's calling moving yellow, moving counties into yellow. This means, of course, big changes for most employers. And that's whether you've been able to stay open to date as an essential business or life-sustaining business or not. Those that are changing into a status that they're able to do things they didn't used to will have huge changes too. Big changes are important from a legal perspective because big changes typically mean you have to make employment decisions, usually staffing up decisions, decisions dealing with bringing people back or changing the way they work or the amount that they work. Every time you make an employment decision, you have what's called a tangible job action that can give rise to employment law issues. I'm going to focus today on 4 steps that I think are key steps to making sure you bring back employees who have been working remotely or employees who haven't been working at all. Number 1 is getting the workplace ready for people that haven't to date been in the workplace. Number 2 is preparing employees for a return, because employees, like people, generally don't like change. Giving people notice and advanced communications is a big part of making sure you deal with issues up front. Number 3 is making a clear return to work offer. It's really important to make sure that when you're bringing someone back, either who hasn't been working at all or has been working remotely, they know exactly what you're asking of them. And then, of course, being ready, number 4, to handle those responses. Handle what are the myriad of things you can get back from an employee once you offer them a return to work. So let me take each of those in turn. Number 1 is getting the workplace ready. There are many things for an employer to consider and address to make a workplace ready, either a workplace that hasn't had any employees in it or has had reduced staff. The general categories of issues you have to worry about in terms of getting the workplace ready are density issues. The science is pretty clear that this virus spreads when a lot of people are in close proximity to each other in denser situations. So most of the guidance and regulation out there has to do with density issues. So things like thinking about whether you're going to return people in stages. So rather than have 120 people all show up back in the office on the same day, are we going to bring back 20, 30 at a time? A lot of organizations are bringing people back in shifts. So instead of having everybody have the same work hours, skew those work hours, have weeks on, weeks off, maybe Monday, Tuesday, Wednesday versus a different shift. That's a lot of activity right now is related to that. Spacing of desks, rearranging the furniture, putting up barriers, things that will reduce the contact, looking at touch points. So a lot of places are looking at the re-engineering of things so you can cut down on the doorknobs that someone will have to need to touch to get into the office, etc. A lot of places are looking at closing public areas, break rooms, kitchens, lunch areas, even dealing with spaces like bathrooms and so forth. Redirecting workflow. Some offices are looking at one-way hall workflow, so certain hallways are one way and certain hallways are the other way. Those are under the category of density. There's also a lot of attention being paid to cleaning protocols, upping cleaning protocols, having certain spaces disinfected and cleaned more often because they are common touch areas. Protective equipment is, of course, an area that's getting a lot of attention in the news. If you're going to bring people back, you'll likely have to deal with issues like, are we going to require people to wear masks? Are there other types of equipment? Securing that type of equipment, buying enough hand sanitizer, buying enough disinfectant spray, things of that sort. And then, of course, identifying and handling COVID-19 related risks. So when it comes to identifying and handling COVID-19 related risk, what we're really dealing with is what happens if you suspect that someone who has arrived at the office may be showing symptoms. Are you going to deal with issues like taking temperatures or requiring people to certify that they're not symptomatic, requiring people to give you notice if they are in a household with someone who is showing symptoms or who has been diagnosed? What are the protocols for that? And a lot of that will need to be addressed in policies that you didn't used to have. Now, when it comes to these getting the workplace ready issues, there's a lot of guidance. So I'm not certainly going to review all of that or go into a lot of that in detail in the short time that we have here, but I have included in the PowerPoint deck links that I think are particularly helpful. The guidance that's out there is both public and private in origin. So for example, on the public side, there are lots of government entities that have given some very helpful information. I've listed on the PowerPoint slides links for the Department of Labor. They have compiled a lot of information. Some of it is theirs, some of it comes from other government agencies. That link is available. OSHA, the Occupational Safety and Health Administration, has given a lot of information. There's a lot of information in there that is industry specific, so things that have to deal with specifically retail settings or healthcare settings. There's a lot of information that drills down into issues that pertain to those types of employers. There's also the CDC. There's a lot of information. from the CDC that you can see in the link I provided. Also, in addition to those federal government sources, a lot of states, including Pennsylvania, the state that I'm in now, has offered guidance. I've given 2 links for those who are in Pennsylvania. If you're in a state outside of Pennsylvania, please search online for your state's either health department or governor's office. The 2 links I've provided for Pennsylvania talk about general guidance for businesses that the governor's office has given, and also kind of specific information about what each level of reopening means. There's still a lot of very specific things that employers need to keep in mind as we go from red to yellow and ultimately to green. I want to circle back to OSHA, which I mentioned. OSHA has given some very specific guidance. I've given 3 separate links in the PowerPoint deck. There's separate pages for specific guidance of preparing workplaces for COVID-19, temporary OSHA guidance for respiratory protection standards, and also a COVID-19 page that talks about information prevention, policies and procedures. Will, I know you have a lot of experience dealing with this with your clients and customers. Would you like to add your 2 cents here?
Sure. Thank you, Albert. So this is Will Collins, also with First National Insurance. And my role is insurance broker, but also risk manager. And so from a guidance standpoint, what we're looking at is a changed climate for employers. Traditionally, guidance from OSHA was pretty predictable, and employers knew what they needed to face and what they needed to look at. So this is going to be an evolving template over the next 6 to 12 months. And what we're looking at is kind of a mixture of OSHA, CDC, and then state and local health departments. So when you look at general information for employers, you're really considering what decisions they take or don't take, and what sort of litigation can arise out of that. And so we're seeing that there's going to be projecting to be an increased risk of volatility in directors and officers and employment practices related lines of coverage. So when you look at OSHA, employers are obviously regulated by OSHA to provide a safe workplace, but when we talk about PPE and social distancing, disinfecting, and the type of work environments we create, there's still going to be a burden on the employer under the general duty clause to provide a safe work environment that is up to date with guidance provided by the CDC and OSHA. So like Albert mentioned, these sources, we should be checking these on a regular basis to make sure that we're in compliance. And if we have concerns, reaching out to your insurance carrier, your risk manager for specific support and guidance as it relates to this. Albert?
Thank you very much, Will. I'm going to move on to the second piece that I was talking about, and that is once you've prepared your workplace for return, you have to prepare your employees for return. Most people, including most employees, don't like surprises. Legal risks tend to be magnified when employees are surprised. So effective communication before specific return to work offers are made is critical for both legal and non-legal reasons. From the non-legal side, things like morale, things like confidence come when people have some time to adapt. Employers who reach out to folks and say, come back tomorrow, typically are going to have to deal with more issues than employers who reach out ahead of time, kind of preventively, and say, hey, for example, hey, we know that the governor has done this, effective this date. We want you to know that we're working on it. We will circle back with steps that we're taking. We're going to give you some detailed information about our plans. Some things are up in the air, but we'll let you know in advance of any people being specifically reached out to come back. Those things have a huge impact from an HR perspective. So the way I would put it is follow the early and often rule when it comes to communicating with your employees. It's the same kind of communication that makes a lot of sense and has some big rewards to it in a non-COVID world. Well, in this particular climate, it's particularly important. So once you get your workplace prepared, you communicate and get your employees prepared. When you get to the point of making overtures to folks who either haven't been working at all or been working remotely or in some reduced capacity, making a very clear return to work offer so they know what you're asking them to do is very, very critical. One half a step before that, it's important to make good, defensible, non-discriminatory decisions about who, when, and under what conditions you are bringing people back. There's many employers who aren't going to bring everybody back who hasn't been working all at once. They're going to stage it. It may have to do with supply chain issues. It may have to do with ramping up equipment. It may have to do with a lot of things. So as you're looking at bringing back some people first in waves, please realize that every decision you make to not bring back someone is a potentially tangible job action. So it's very important, like all other decisions you make, to bring back people or affect people in a way that touches their pocketbook. Be very clear that those decisions can be challenged by people who don't like them. Someone who thinks they should have been called back earlier, for example, and move somebody else, those can be challenged through the typical legal means. The legal considerations, for example, like discrimination. You want to focus on issues like discrimination on the basis of age or sex, and also some PPP loan forgiveness. Those are things that can impact these days. But before I go into more specifics about some of those things, let me throw back to Will. I know he has some claims related to decisions you make now about bringing or not bringing people back. Will?
Thanks, Albert. So we are starting to see the first actions in terms of claims come through, and the industry is projecting the concentration of claims, and we're going to focus specifically on employment-related claims here, but the industry is projecting a concentration of claims in certain areas, and discrimination is looking to be the loss leader here. Discrimination as it pertains to rehiring of employees or looking at potential new hires, but one of the big issues that's out there is denial of employee rights because of the perception that they are COVID infected, and how that's impacting current and prospective employees. There's also going to be big concerns surrounding employee privacy. If we're doing the sort of screening in terms of temperatures and things like that in the workplace, how would that potentially broach into the HIPAA violation realm, and how would your employment practices policy respond to that sort of violation if other employees were made aware of the medical condition of an employee that was either infected or not infected? Obviously, you've got issues with workforce reductions and suits that can be brought by employees out of that. But don't forget too that if you've maintained operations through this pandemic and it's changed your workflows and specifically overtime payments, that can lend itself to some pretty significant wage and hour violations. And that's not something that is necessarily covered on every employment practices policy. So become very familiar with what your policy does or does not cover. I think that it's going to be critical to know what you have in place, what controls you're maintaining to make sure that you're mitigating the ability for employees to bring claims against you. And I think the last thing that we're really anticipating seeing a lot of activity out of are whistleblower and retaliation claims brought by employees who allege that their employer disciplined or discharged them for complaining about the health and safety concerns related to COVID. I mean, obviously, you're going to have employees that all have, more than likely pretty strong opinions one way or the other about how the workplace should be structured and run, and the way that you manage those and manage those specific employees' concerns and the outcomes from those is going to be very critical. So lean on your labor attorney, lean on your insurance broker and the risk manager to provide sound guidance there to thwart any potential issues. Albert?
Thanks, Will. Now, on the issue of discrimination, every business has, long before coronavirus, had to make sure that as they make decisions about who to hire, who to fire, who to promote, and so forth, has always worried about discrimination. So whatever instincts have gotten you success in that area, make sure you don't lose those instincts now. And the key way to inoculate yourself from discrimination cases, or at least reduce as much as you can the chances of one, is to make things based on legitimate business reason and need. Business reason and need. Notice what that doesn't mean. It doesn't mean a focus on a particular person. So sometimes in the sports, they tell you to play the position and not the person. Same kind of instinct here. So as you're making decisions to bring back, you don't have to bring everybody back. You don't have to treat everybody the same. But what you have to do is make sure that the extent to which you treat people differently is tied to a business need. So for example, if you need 2 weeks of getting the machines up and running, run electricity through them, clean, maintenance, and so forth, of course, you can show a business need for bringing people who are involved in that task back earlier before you bring back the machine operators who are going to run it. And if those machines need to run for 2 or 3 weeks to get the product ready before you ship it, that certainly is a legitimate business reason for bringing back the shipping people last. So things that are focused on the business need will survive scrutiny under the lens of a discrimination claim. What makes it touchier is if your decisions bake into them assumptions about people. So, well, we were going to bring back Albert, but we're not going to, because we remember that Albert has asthma and he's probably worried about this. So if we ask him back, he'll probably say no. That's too much consideration of something other than your business perspective. And then you get into issues like Will said. If Albert finds out he wasn't brought back and there isn't a clear reason, he'll start thinking to himself, gee, my employer must regard me as disabled, and now I'm going to lose out on these opportunities. I'm actually perfectly fine. My doctor's cleared me to return to work. So focus on your piece as an employer. Focus on things that you can tie to a business need. Now, once you make all these decisions from a need perspective, recent events have injected something we're not used to thinking about when thinking about bringing people back, and that is PPP loan forgiveness. I'm not going to spend a lot of time on this today because not everybody on this call has applied for or received a PPP loan, but we certainly know a lot of clients who have, and the PPP loan forgiveness provisions include certain provisions that care about how much of your folks who have been laid off or have had their wages reduced have those jobs or payroll reinstated prior to a certain date, and that date is June 30th. There's also a separate piece of the forgiveness puzzle that does a kind of before and after picture, looking at periods that go either from last year or early this year compared to your payroll and headcount for this year. So certainly, as you make decisions, if you're thinking about those issues, please consult and get legal and accounting advice for those things. So once you make decisions on who you're bringing back, please clearly communicate to those individuals. The communication should have all the typical things you have in communication. Tell people when you expect them back. Tell them what duties you expect them to do, particularly if there's any difference in their duties. You can have them doing something different from a transitional perspective that's going to take more of their time than some of the stuff they used to do. If you're going to have them work different work hours, for example, because you're trying to stagger people coming in and out. If there are other terms and conditions of their work that are different, communicate that up front. Certainly address policies and procedures that have to do with COVID-19 so that people know. Let them know ahead of time what those new issues are at work so that you can address them. Now, terms and conditions. I mentioned if there are terms and conditions that are different than people are used to that you're bringing them back under, please address them. And I know, Will, that's something that you, for your clients and customers, you deal with the insurance issues that have to do with employer decisions on terms and conditions of work, right?
Correct. Yeah, and one of the biggest things that you're going to have when you start returning workforces to normal is, the threat of litigation surrounding actual perceived inconsistencies in applying and enforcing your policies. So, like Albert said, it's critically important to make sure that you're taking a very uniform approach to every employee and don't go with human tendency to be a little bit more specific to individuals, because that's where you can open yourself up to a challenge. Thanks,
Will. So that brings us to the fourth issue. So once you prepare your workplace, you have mentally, emotionally prepared your employees for being called back. You have made decisions about bringing people back, in what order and under what conditions, and you have properly notified them of the specifics relating to that. Once you've made that offer for them to come back, now we get to issue 4, which is to be ready for the entire range and universe of answers you will get back to your offer. Obviously, if an employee says yes, an unadulterated, emphatic, enthusiastic yes, I'm ready to go, I'll see you next Tuesday, then there isn't any issues, and that's great. But what if you get an answer other than yes? And we can all imagine all the different things that can we can hear from employees. After all, even with small companies, but particularly with larger ones, your employees are not a monolith. Everybody has a different set of circumstances. A lot of people have a wide range of feelings and issues and opinions related to what's going on. You may have some employees think that this whole thing has been a hoax, it's been overblown, we should have never shut down, and you may have some employees who have been very, very scared and haven't left the house and are worried not just about your workplace, but what about the public bus that they usually ride in. So I'm going to set up a couple, I think, common answers that you might get from employees when you offer them a return to work, answers other than yes, and we can talk about how to kind of slice and dice them and look at them in a way that will be good from an employment law perspective and HR perspective, and will also help you mitigate your legal risks. Let's say you have an employee who you reach out to and you call them back, and you do all the things we talked about. What if the employee says, do I have to? I've been working at home. You've asked me on a very short notice a month and a half ago to work at home. I set everything up. I'm working at home. I'm getting great feedback from my supervisor that the work is great. Can I just keep working at home? Or you could have someone say, okay, well, thanks for calling me back, but you should know that I've been coughing for a week or so and I have a fever. You can have employees say something like, I'm fine, but as you know, my husband has asthma and a heart condition, and even though I feel fine, I'm afraid of bringing it back home, and that's the reason I haven't left the house at all, and I've been having my groceries delivered for 6 weeks. What if you have an employee that says, thanks for asking me back, but I can't. I have lupus. I'm on immunosuppressant drugs, and my doctor has told me that it's unsafe for me to leave the house and has advised me to self-quarantine. What if someone says, my kids' schools remain closed. It's only mid-May. My kids are learning remotely for another 3 or 4 weeks. They remain closed, and there's no one else to watch them and help with online classes if I leave to go to work. Or what if an employee says, just generally, I'm just very nervous. This whole thing has been crazy. I'm very nervous about leaving the house at all, and I'm reading about the deaths and the issues, and I love my job, but I'm not ready to leave the house and come to work. So you can see that in the category of non-yeses, you have a wide range of things. And the first important thing I want to pass on, the big mistake here is to treat all no's the same. Not all no's are created equal. Although the general rule is that an employer has the right to require an employee to come to work, and when they're at work, to do the duties that are assigned, and many times duties that the employee doesn't want to do. The general rule, of course, employers have a wide discretion to require people to come to work and do the duties assigned. There are key exceptions, and that's the important part of this discussion, is to understand what those exceptions are. There are some situations in which employers do not have an unfettered right to require people to come to work, do have to require people, allow people to miss work, and don't have the right to assign every duty that they want to assign. So how do you know what those exceptions are, and how do you have a systematic way of taking all these non-yeses, all these no's, sorting them out, and figuring out which ones have to be looked at with certain types of legal and HR attention versus the ones that don't? So I'm going to propose a way to do that. If you're my generation, growing up, I remember when I was a kid getting a gift someone gave me a coin sorter that I thought was the coolest thing in the world. You take a pile of change that you have on your dresser, you put it through this plastic gizmo, and it has different size racks, and as you shake the coins through, it notices the different sizes and different characteristics of each coin, and voila, at the end, you have quarters on one side and nickels in the middle and dimes. That's kind of what you have to do here, is you have to take your non-yeses, all your no's, and sort them under the procedure that I'm about to tell you about. So first of all, the first exception you should think about is that you may not have an unfettered right to ask an employee to come back to work or do certain things if you have a contract or agreement that prohibits you from doing that. So if what you're asking someone to do, when you're asking them to do it, and in what order, infringes on a right they have under a contract, for example, a union contract, you have to be very mindful of that. So for those of you who have a collective bargaining environment, you have a union, you have a number of folks in a bargaining unit, be very careful. This is a great time to reread your contract and look at things like recall rights, what order you have to recall folks, what kind of notice you have to give them, what job duties cannot be added to someone outside of their typical job duties. The first thing I want to do, what I call category A in the PowerPoint, is look at contractual issues that deal with that. Now, even in a non-union contract, if you're an employer that has lots of employees with their own individual employment contracts, please take a look at that. So once you're done kind of sorting that kind of coin, the next thing you want to look at are if the thing that you're asking for might rub up against a legally protected right. The employee has to either miss work or have some aspect of their work change. So this will sound very familiar to you. FMLA, for example, has been around long before coronavirus. If you're a FMLA-covered employer, which means you have more than 50 employees within a 75-mile radius, you've always recognized that there are 5 categories of reasons that people have a protected right not to be at work and can't get into trouble for being away. So, for example, if you have a serious health condition, you're taking care of a close family member with a serious health condition. You have certain military obligations, including those relating to being on active duty. You are giving birth or adopting or taking placement of a foster child. FMLA has always said that covered employees or employers who have to deal with FMLA can't get in trouble for missing work up to 12 weeks a year. So that applies here too. So if you have someone say, yes, I understand you're calling me back, but I have a serious health condition, and this serious health condition incapacitates me for work, you have to take out the FMLA analysis and turn the crank and make sure it comes through. So that's pretty familiar. One thing that might not be familiar is the Families First Coronavirus Response Act. This is a law that was passed just a couple months ago specifically to deal with coronavirus. It gives six different reasons why people have a right to miss work that are COVID related, and in each case, a right to not only miss work, but have a paid leave for that. Now, those 6 things are very, very specific, so please don't think that every coronavirus-related issue is covered by the Families First Act and is a reason that people can get paid leave. It's not. I don't want to go into all the details, but it's typically things like your own condition. So you've been told by a healthcare provider to self-quarantine. You are exhibiting symptoms and awaiting a diagnosis. Or with relation to other people, you're taking care of an individual who's been told to self-quarantine, or you're taking care of a child whose school or daycare is closed or is unavailable. Those are very, very specific reasons. If I'm sure you've been exposed to a lot of information. If you want some specific information, you can always check out our website. We have a COVID-19 page that includes an article that I wrote. If you want to search for an article I wrote that's dated March 31st, it deals a lot with the specifics and updated guidance relating to the Families First Act and paid leaves. It also includes some sample forms that employers can use, because you do want to document that right. If someone takes a leave and you treat it as a Family First Leave Act leave and you pay them, you can be entitled to have that payment offset through a payroll tax credit, but only if you dot the I's and cross the T's. So employers shouldn't be in the position where they pay someone thinking it's Families First, but not all the boxes are ticked, and therefore when they go get seek the payroll tax credit, it doesn't come through. I want to make sure that folks don't deal with that. You also have to look at state or local paid sick leave acts. A lot of them cover situations that are beyond an FMLA mindset. One example is in the place I live and work, Pittsburgh. Pittsburgh, just literally days before the coronavirus shutdown orders came, Pittsburgh's paid sick leave law went into effect. That has some extremely specific rights that people have to accrue paid sick time and use it for situations like someone's own illness, or to take care of someone else who has an illness, or if there's a public health emergency. So please make sure that your HR function is very aware of this layer, this kind of layer B of all the laws that can protect someone's right to miss work. So C is if someone isn't unable to work in total, but they say they can do only part of their job or in a certain way. Someone who requests the right to work at home, someone who requests the right to have shorter hours or have certain accommodations or equipment at work, or even the lack of equipment. If you have a general rule in coming back that everyone needs to wear a mask, but someone says because I have COPD, my doctor says I can't wear a mask all day long, anybody who says they can do some of their job but wants you to consider some change to other parts of their job, that can be what's called an ADA accommodation. Again, the ADA is something that's been around for a long time, so your HR function should have a way to deal with ADA accommodation requests. It's a very specific way. It has to do with concepts like interactive process. It has to do with dealing with someone's functional issues, not the underlying condition. You can ask for some type of information. You have to kind of come back and forth to make sure you understand what accommodation, maybe other accommodations other than the one that was asked for, can be made, and if so, how that accommodation gets evaluated. You only have to make accommodations for disabilities if they're reasonable, which usually means doesn't, become unduly burdensome for you from a financial standpoint. So look at ADA and state local laws if someone says they can do part of their job but not all of it. And the last thing you want to look at here is once you look at contract issues, union contracts, once you deal with laws like Families First and FMLA and ADA, look now towards your own policies. So people have a legal right to avail themselves of policies and procedures you've created, separate and apart from legally obligated leaves. So look at things like your own policies related to PTO, sick days, vacation, personal days. Most states, and this is something that does vary considerably from state to state, most states require you to follow your own procedures. So most states don't make you give PTO, but once you do, make you follow the plan or policy documents you issued. And although in most instances you can change them, you can usually change them only prospectively. So this is a good time to kind of dust off your own policies and procedures, look at them, and make sure they fit a coronavirus world and fit the situations you might anticipate. And if you need to make changes, make the changes in the way that we talked about. So let's say you go through all that and you sort your quarters, dimes, and nickels. You're done with what I would have called in the PowerPoint deck A, B, C, and D. Now you're left with situations where you don't particularly have a large legal obligation. You've ruled out the contract issues, the statutes, and your policies. So it's a good time to determine whether you want to issue new policies and procedures to deal with these extraordinary circumstances. Do you want to, for example, look for volunteers for people to come back to work, even though you otherwise don't have a legal obligation to do that? There's a lot of job sharing suggestions out there so people can job share, modifications to your PTO or leave policies to either tighten them up. A lot of employers are worried that people who've been working remotely, for example, have passed up on vacation time they would otherwise take because nobody can travel, and some employers are worried about an avalanche of PTO or vacation requests when people come back. So you can do some things to moderate that or modulate that, or you can even create new leave policies to give people the right to miss work under situations that you're sympathetic to but may not be covered. So those are my 4 steps. I've also written an article that's on our website that talks about the general considerations, labor and employment considerations in a COVID-19 world, you can certainly feel free to look at that. Our website is in the PowerPoint. It's www.tuckerlaw.com. Now, Will, I know I touched on some things that you were able to jump on, but I know there are some things that are very important in your role that I didn't, so I'm going to throw it back to you.
Sure. Yeah, I think, Albert, the thing that I would wrap up with, and policy review, and this, like we mentioned at the beginning, this is going to be an evolving science with, kind of how things trend as we slowly reopen. But I think that, now is an appropriate time for all employers to be evaluating their policies and procedures that are in place, discussing with legal, and then ultimately need to be looking at what function of transferring that risk in the event that something goes wrong. What function of transferring that risk do they have in place, and how does their policy respond? Most of the folks on this call, if they have employment practices, know that those policies are very unique. There is not a boilerplate policy out there. They typically are very diverse from one another. So when we talk about things within the employment contract, FMLA and those sorts of things, some carriers will cover it, some carriers will not, most will. But, when we talk about collective bargaining agreements, unions, oftentimes that's an exclusion. And so just need to be very aware about what sort of protection you have in the event that you take the right steps, but, something unfortunate happens. What protection is out there? Are there things that you can be doing to strengthen your protection? And I think really, for the folks on this call that are typically, have oversight or involved in the purchasing decisions of their insurance coverage, just know that underwriters are looking at these same concerns. So the risk is not going to go away. It's only going to grow. Most underwriters are in the mindset that we're preparing for a second wave at some point, which is going to drive, more claims activity. And that second wave, if it does come, is going to bring higher scrutiny to management, with the, kind of the assumption that you all should be more prepared for at the time of a second wave than we were for the first one. So, be expectant of coverage becoming a little bit harder to secure in the employment-related space and D&O space. Plan for more lead time around your renewal process. Make sure that your policies and procedures are tight. That will help you in your negotiations, and expect a lot more questions from underwriters surrounding COVID and any actions or inactions you've taken. And I think the last kind of takeaway for me would be, as you're going through those renewal cycles and working with underwriters and carriers, be very aware of knowledge exclusions and warranty statements. We're in uncharted waters in terms of what could give rise to a claim, and all of those applications have warranty statements where they're asking you to disclose of any knowledge of anything that could give rise to a claim. So just be very cognizant on how you answer those questions. Supplemental information is good, and now is an appropriate time to do your due diligence internally and make sure that all three pieces of this talks. Thanks, Albert.
Sure thing. And at this point, I will turn it over to Tom Cray from Holsinger.
Thank you, Albert. Appreciate being in the webinar today. I want to thank Albert specifically, and also FNB, and also Tucker Arnsberg and the team there of Allison, Ben, and Matt getting this thing going, and appreciate you all helping out with this. So myself and Andy Bianco are going to try to distract you all now with some tax and accounting and M&A information as you're typing up your specific facts and circumstances employment questions for Albert. If you may have jumped in late, you can submit written questions to, there's an email address that I'll read, and if I get it wrong, Albert, please jump in, but I believe I have it correct. It's A as in Apple, Hurley, Hurley, at tuckerlaw.com. So that's AHURLEY at tuckerlaw.com. And then, of course, as time allows, we'll get to those questions at the end. So Now I'm going to introduce my partner, Andy Bianco Jr. For those of you that are familiar with Holsinger, historically we've had a sister company, Steelgate Advisors, which is a full-service investment bank. As of January 1st of this year, we merged with Strategic Advisors, and Strategic Advisors will be, the sister company investment bank brand going forward. So for those that are familiar with Strategic Advisors, there's Andy Bianco Sr., who's the founding and managing partner of that group. So now we've got a father and son team working together that we're very excited about. So to avoid any confusion, you'll see slides later for Strategic Advisors. That's the sister company of Holsinger. And who's going to be speaking now about tax-related topics is Andy Bianco Jr. and not Senior. We'll get Senior on a webinar sometime in the future. So Andy, take it away.
Great. Thanks, Tom. Thanks, guys, and thanks everybody for staying with us this long. I'll try not to bore everybody too much with the tax stuff. Point of importance here, I want to just talk about the layout of the tax slides that you guys were all provided and have available to you. In most cases, it's usually less information on the slides and more information in the talking, but because of how nuanced the tax code is and how many different ways some of these changes can apply, what we wanted to do here is to make the presentation piece of this a higher level discussion, but include a significant amount of detail in the slides that are attached here too. So that being the case, if at any point a question arises about something that I may have skimmed over quickly or in not as much detail as presented in the slides, please feel free to ask and reach out. So with respect to the tax updates, there were a number of items that were specifically changed as a result of the enactment of the CARES Act. And what those changes were aimed at or surrounded were the ability to create tax favorable circumstances from a business and an individual sense. The way that was done was to relieve certain restrictions in a lot of cases, and I should mention that temporarily relieve certain restrictions that were established by the formerly enacted Tax Cuts and Jobs Act. So that act was established and enacted in 2018, specifically actually late 2017. So the changes made by that act were considered in a lot of ways favorable, but included certain restrictions. And those restrictions were the items that were focused on in the CARES Act. So what we'll talk about today specifically will be the qualified improvement property technical correction, the Section 163J interest expense limitations, business loss limitations, net operating loss carrybacks, and Internal Revenue Code Section 265. So to start, we will go to our qualified improvement property technical correction. So the technical correction here was born by the fact that the Tax Cuts and Jobs Act, when enacted, it had an initiative to simplify and condense the definitional language surrounding qualified leasehold improvements, qualified improvement property, and things of that nature. So while it succeeded at unifying a single definition of qualified improvement property as qualified improvement property, the outcome was actually, it was difficult to accept, considering the fact that the code section was not necessarily finished. And in that case, and because of that, what ultimately happened was a reversion of what was formerly deemed a 15-year piece of property to a 39 or 27.5 year piece of property. So what does that mean? That basically means that the ability to recoup your investment on what could be a substantial capital expenditure then was extended, making it less beneficial from a tax perspective to invest in things like qualified improvement property. It also created a situation where by increasing the useful life past 15 years, we were no longer permitted to apply things like bonus depreciation to these pieces of property. And if for anybody that's been following along on the most advantageous of the tax changes that happened in 2018, that bonus depreciation is significant at 100% today. So this technical correction that came through the CARES Act was specifically aimed at clarifying that the intention never really was to revert the useful life of items deemed to be qualified improvement property to 39 or 27 and a half years. Instead, the intention was to retain a 15-year characterization from a tax depreciation perspective. And in addition to that, allow for things like the application of bonus depreciation at 100% until that sunsets to 80% later on down the line, and allow taxpayers to plan in that way. So what happened here was over the last couple of years, what we have found is that taxpayers have taken one of two perspectives on this. One is that they believe that the intent of the law was to allow you to have a 15-year useful life on these things, so they took it anyways. In that case, there would not be a change. Whereas the alternative exists in a lot of cases where a conservative approach and a conservative outcome was to consider qualified improvement property to be have the extended useful life. In those cases, you now have the opportunity, depending on the duration of that interpretation and the duration of the the time frame during which, or calendar years or tax years, that you actually applied the extended useful life. There's two different ways really to go back and correct this. So one of the ways is to file Form 3115 on an amended return, and the other way is to file which would apparently or would clearly have a retroactive effect. So it would place the benefit of the change in accounting method back a year into 2018, whereas the alternative is that you have, under certain circumstances, the ability to correct that in 2019 or even in 2020 if 2019 is already filed. The benefit, or the importance of making that statement, is that you indirectly now have an ability to potentially time a deduction, which is a rare occurrence in tax land. So time deductions are something that should be planned for carefully to make sure that you're setting the deduction in the year in which you want it to exist, or in the year in which it'll be the most beneficial to you. So that's just an important consideration or discussion to have, and a consideration to have when potentially correcting this issue by means of the technical correction through the CARES Act. So following our qualified improvement property discussion, we're going to talk about the business interest deduction limitation. This, again, is another code section enacted by the CARES Act, or by the Tax Cuts and Jobs Act, and it was the intention of this section was to limit the deductibility of interest based on business income in any given year. It specifically pertained, in our experience, healthily, I'll say, to real estate investment companies because of the structure of those types of investment companies. But it can apply in a broad, sweeping scope across any entity, really. So the original language read that you could not deduct interest in excess, and this is very generally speaking, in excess of 30% of taxable income in any given year. The CARES Act came back and said, we're going to suspend the restriction at 30% and replace it with 50% on a foregoing basis, meaning that you now have the opportunity to deduct more interest than you formerly could because of the language in the CARES Act. That's a good thing, except for by the time the CARES Act was actually enacted, it had surpassed the time frame for partnerships to actually file their tax returns on March 15th. Because of that fact, this specific change or caveat only applies to entities that are not structured as partnerships and individuals for tax year 2019, and then applies to everybody in tax year 2020. The importance of that is that we have received a lot of questions, and I likely will continue to receive a lot of questions, is what happens when, do we have the ability to go back and amend a tax return that was filed for 2019 as of March 15th to take advantage of this increased limitation? So generally the answer is going to be, if it's related to a partnership, it's going to be no. We're not going to be able to do that. And I think that it's clearly intended to not create that situation, considering the people that are impacted by this are generally multi-partner, limited partnerships, large real estate investment companies. It would have a rippling effect across a number of individuals and entities and economic units that could create a whole lot of confusion as it pertains to amended returns and amended taxpayer filings. The other thing to keep in mind with the interest deduction limitation and the changes there too are that that 50% rule applies to in 2019, if you're not a partnership, to 2019 taxable earnings, meaning that you take the 2019 taxable earnings times 50% to establish a baseline of deductibility for interest expense. In 2020, because of the COVID impact, the CARES Act actually further stipulated that if your earnings are down in 2020, you are permitted to elect to use 2019's income against the 50% limitation rather than 2020's in order to increase the deductibility of interest that you are able to have through Section 163J. That's a pretty significant benefit, considering we're going to probably see that their companies are going to have financial distress or some financial strain as a result of the restrictions that COVID applied or that it introduced into the economy. So now what you're saying is use a higher number to limit your interest deductibility, which is a good thing, and potentially create a higher loss. What you're going to see in the next part of our conversation is that because of the other provisions enacted by the CARES Act, the higher the loss, the more substantial the benefit can be to a company or an individual on a foregoing basis, or at least through the end of 2020, as a result of these other changes that were made as well. So moving on past business interest deductions through 163J, we're going to talk about the, and I guess I should mention, to recap quickly, there's examples of the calculation of this limitation in our presentation materials that are available to everybody. So moving on, we're going to move on to business loss limitations. So what I should mention here is the next two sections, the business loss limitations and the NOLs, really, I would say that the culmination of these two specific items and the other items that we've already discussed are the ultimate, they are the tax planning objectives that should be enacted or should be considered in 2020 and 2019 if you haven't filed yet, because consideration of all these things together can create really tax beneficial results for companies and owners for the next year or 2 years here. So the business loss limitations, specifically Section 461L, formally established by the Tax Cuts and Jobs Act, basically stipulated that a taxpayer could not offset taxable income from other sources in excess of $500,000 for business losses that were outside. So what that means is we have multiple sources of income. Those multiple sources of income are unlimited in impact on your tax return. However, if we have multiple sources of losses, we cannot create a situation as a married taxpayer where we deduct more than $500,000 of those losses per Section 461L. The CARES Act said, okay, we need to remove that restriction and we should remove it retroactively. So what the CARES Act established is that the Section 461L loss limitation now no longer applies to tax years 2018, 2019, and 2020. So that's extremely important for a couple reasons, and we'll get into the impact of the net operating losses here to come. But the important part to consider here is that we now have the opportunity to go back and look at our 2018 tax returns and say, if I was not limited from a loss perspective, and this is a taxable loss perspective, and that taxable loss could have arisen from a zillion different reasons, but can I go back and amend my tax return and claim a refund just by nature of the fact that this $500,000 limitation doesn't exist anymore? That can be a very, very substantial benefit in and of itself. But that benefit in conjunction with the benefit of the net operating loss carryback then creates an even more substantial benefit. So if we move forward to our net operating loss modifications, what happened in the Tax Cuts and Jobs Act of 2018 was that we were no longer permitted to carry back losses. And that had a whole lot to do with rate differentials and the new rates established by the Tax Cuts and Jobs Act. Basically, the idea here was that if you create losses after the Tax Cuts and Jobs Act was established, you can use them thereafter, but you can't carry them backwards to a higher rate environment and then play tax rate arbitrage and essentially bolster a benefit of a loss created in a later date as it pertains to an earlier tax amount paid. We now have the opportunity through the Tax Cuts and Jobs Act to create a situation where we can carry back our losses. And not only can we carry back our losses, we can carry them back for 5 years. That creates a tremendous tax planning opportunity in and of the fact that now we have a distressed economic condition that's going to create tax benefit by nature of the fact that profits are probably down. We have 461L limitations being removed, which is going to increase losses that would have otherwise existed in 2018 and 2019 if filed before the change was enacted. And then lastly, we have other tax planning opportunities through things like the change to the qualified improvement property, the increasing of the interest expense deductibility, and all those other things, which together now let us do some very, very tax beneficial planning for businesses and owners of businesses. So the net operating loss carryback, I guess, to further explain, and you'll see a whole lot of procedural information in here, because the first question everybody asked when they established this specific provision was how. I will say that only recently have they come out with guidance as far as how, and it's still slightly suspect as to what the process and procedure, or how, we know what the process and procedure is. We don't know how well it's going to be received at the IRS, considering the lack of manpower and the technical delays and communicational difficulties that are encountered by them not being in the office, any agents of the IRS. So ultimately here, points that should be made is that if we are going to file a refund claim as a result of a net operating loss carryback in 2019, the simplest way to do that would be to file it before June 30th of 2020, but on a Form 1145 or 1045, I apologize. So in order to do that, though, we need to make sure that our net operating loss claim matches historical tax forms. Well, we just talked about with 461L that the historical tax forms are now changed. So the difficulty herein procedurally lies in the fact that we have to go back and amend our 2018 tax return, submit an amended return, and file a NOL refund claim with our 2019 return, and hope that the IRS receives everything and is able to match all the numbers without simply saying, forget it, I'm rejecting the claim because we haven't processed the 2018 amended return yet. So simply put, while this is a very, very tremendous benefit, and while there's very good tax planning to go along with it, it's probably going to take a little bit of maneuvering as it pertains to the company's financial team and your tax advisors and how these things are filed. It's very important that you go in with a plan, and it's very important that you maintain accurate and complete information as it pertains to these claims, so that in instances where these do get kicked back, and they will get kicked back, there's quick and timely responses so that we're not further delaying the process with those types of items. So that being the case, that really kind of concludes, let's say, the CARES Act piece of the changes related, or of the tax changes. Now, in addition to that, I wanted to add one more section to this portion of the presentation. This last section is Internal Revenue Code, Section 265. Why this is important is because this specifically relates to the PPP, which has impacted a series of, or an immeasurable or a significant number of companies in the United States to date. So the intention of the PPP, and we won't get too much into the spirit of it, was to aid companies during a difficult time with cash flow concerns, and really, really, importantly, keep your employees employed and keep paying them what they were making before. The other thing that was specifically, or let's say broadly publicized, was that there won't be tax associated with the PPP and respective loan forgiveness. That's something that everybody kind of hung on to and thought, wow, this is a really, really tremendous benefit that can be afforded to my company because I'm essentially receiving free money. Well, ultimately, later on, it was recognized that Internal Revenue Code Section 265, which has existed well before the Tax Cuts and Jobs Act or the CARES Act was established, now applies, and that can apply in a way that creates taxability of a portion of the PPP proceeds that are received. And it does it indirectly. So while the PPP has established and the CARES Act has established that the cancellation of indebtedness is not taxable as it pertains to PPP proceeds received and forgiven, Unfortunately, Internal Revenue Code Section 265 says that tax-exempt income cannot produce deduction. So now we're talking about 6 in one, half dozen in the other here, where we won't get tagged for tax as it results or as it pertains to cancellation of indebtedness, but our income is going to be inherently higher by the amount of the loan forgiven because we won't be able to deduct the associated expenses. For a while, and when I say a while, a week seems like a year when it, as it pertains to the PPP and CARES Act matters, but for a short while, it was unknown as to whether or not this code section would be enforced. And it wasn't until recent that the Internal Revenue Service actually issued a publication specifically stating that it will be enforced and that they fully intend on applying this specific code section to amounts forgiven under the PPP loan and related expenses. That being the case, we now believe that let's say the direct path here is that we probably would not want to contest, or we may not want to contest the IRS's publication. That, taking it one step further, however, Congress has recently come out and stated that it was not the intent of the law to tax any portion of these proceeds or the forgiveness. That being the case, we clearly have a little bit of a battle going on now, and we're not really sure what the ultimate outcome is going to be, but as it stands today, the IRS is likely the governing authority as it pertains to tax, and they have specifically come out and established that they intend on enforcing this code section and taxing the non-deductible expenses because the cancellation of indebtedness is not taxed. So all being said, that was a long-winded way of going over these things. What I want everybody on here to take away from this is that these tax planning opportunities are new and temporary. So some of these things, like the qualified improvement property, is it going to be an indefinite correction to the tax code? Wow, and scattered throughout each of these code sections, there's other technical corrections that were passed through the CARES Act as well that are permanent. But generally, these specific items, there's provisions that were enacted as a result of the CARES Act are temporary and that they sunset in 2020 or at the end of 2020. So tax planning that you will receive very tax advantageous benefits from has to be done now, not later. So you should be in front of your tax advisors and speaking with them about these things so that you can figure out a way to triangulate the effects of all of these things into the right tax answer for you or your business. So I'll leave you with that. At that point, I'll kick it back to Tom, who's going to talk to you about some accounting and M&A stuff.
All right, thanks a lot, Andy. So I'm going to jump into some accounting and audit issues and also an M&A update. You know, the important thing to realize here is that, you know, I know there's a lot of diverse people on this call, so I'm not going to dive into the intricacies of GAAP and the FASB codification. I'm going to run through these issues at a high level. You know, this is really meant to get you thinking about this and having conversations with your accountants and auditors, you know, to be prepared for some of the questions that are going to come up, whether it's from auditor or from a bank, you know, or other stakeholders, you know, in your operation. And so I'm going to be starting in the PDF slides on it's slide or it's page 54 of the PDF. So the first thing that nobody likes to talk about is asset impairment. When you're looking at this, it's really important if you're under an audit, you know, management needs to be prepared with this analysis in advance. And I think that in this environment, there may be a increase in outside consultants that are utilized in preparing some of these because your auditor, you know, should not be preparing these assessments. You know, this is all, you know, on management. And so, you know, as you look at as you look at impairment, you know, you really work down the balance sheet and you start with, you know, your working capital items that I'll talk about on the next slide. And then from there, you look at indefinite lived intangible assets, you know, which is under Section 8, ASC 350. And then after that, you look at PP&E, you know, and those impairment issues, and then finally goodwill. One thing to point out is that, you know, if you do end up recording any impairments, you know, that's not reversing that is generally prohibited by GAAP. So you want to be sure that you get these analyses right, and that it's better for an organization to control the message, before, and have the answer ready and have the analysis put together before the questions are asked. That's really the way it's supposed to work, and shows better preparation for that. So that's something that maybe organizations are not used to doing, or is not as much of a important thing under different circumstances. On the next slide, we just have some information here on inventory. If you have a business that includes a lot of inventory, these are not issues that are unfamiliar to you. The obsolescence and slow moving inventory reserves, and what used to be called LCM analysis, and now it's the LCNRV analysis that needs to be done based upon what's happening in the market and things like that. That's something that you should be looking at now and starting to think about where that's going to land with periods of inactivity or slow moving sales and building up inventory. There might be things that fall off at the end based upon the methodology you've used to determine those reserves in the past. And it's always a good thing if you think you might need a reserve at the end of the year, instead of waiting and hoping and then having to crush December and have a big adjustment at the end of the year, build that up slowly throughout the year. Same thing with accounts receivable. There's going to be increase in bad debt reserves for sure. In this environment, something that you should be looking at now. One item that probably doesn't get a lot of look or time from an impairment perspective under normal circumstances, equity method investments. Usually, you just kind of update those and move on, and the auditors don't ask a lot of questions. But in this environment, that those items could be impaired, and so you need to be looking at that in advance. The key thing there is it needs to be an other than temporary impairment. So if you think it's going to recover, then you might be out of the woods, but it's worth looking at. And then just an overall cash flow treasury management item is that in this environment, you can't just be forecasting your P&L. You really need to be forecasting your balance sheet. That's for two reasons. One is you got to get the accounting correct and have some of these things nailed down before the end of the year. But also working capital is going to get tighter, and your borrowing base, if you happen to be in an ABL situation, you need to have some ability to see the crunch before it happens. And if your receivables are going to age, your inventory is going to age, there might be certain components of those, typically adds to your borrowing base that might fall off for whatever reason. So it's critically important in this environment, to be looking at all aspects, of your, the forecasting. On the next slide, consolidation. This is something that probably isn't thought of throughout the year at all by most entities. If you happen to know what the acronym VIE stands for, you probably have some brain damage from it that you're still trying to recover from. But this is an issue that under these environments where things are happening, there might be restructuring. There might be revisions to, bylaws or voting rights for entities. There might be things that are bankrupt or sold off, or troubled debt restructurings, refinancing. There could be all sorts of things that, happen this year or going forward that could change judgments or conclusions that were made, by management and approved by auditors related to consolidation, especially surrounding VIEs. So it's something to, not wait until the end of the year to look at. This is a very, challenging area of GAAP, and there's lots of judgment involved. And there's also new guidance out, ASU 2018-17, that provides some relief for private companies. Can be a saving grace there if there's some new entities that might have to be consolidated in a reporting entity. But these are all things that you really need to be paying attention to sooner than later. Next slide is on contingencies, specifically insurance recoveries. This is an area that, a lot of companies are going to get into, and, GAAP generally does not, or generally frowns upon recording contingent assets. There are certain circumstances where they can be recorded, but, there's a lot of judgment involved, and that really, needs to be a collaborative effort. Don't assume that your auditor is going to be okay with that. Call them. And there's, business interruption claims, those can drag on for quite some time. You might want to be telling your bank, oh, this is coming, but it's hung up in litigation, or there's uncertainty in what the recovery will be. So these are all issues that, you really got to get in front of and have some analysis behind. Business interruption, there's a lot of specific GAAP guidance, on that as far as how you classify that income. And there's actually some leeway there. So those are all things that are, important to look at and consider. All right, next slide. I'm gonna start talking a little bit about the accounting and auditing issues related to the PPP loans. This loan is a loan, and so you must record this and disclose it at its terms, which in most cases are pretty straightforward. My opinion on the forgiveness aspect of it is that it's a contingent asset. You're not recording that until it's absolutely certain it's been granted. This can cause problems for entities where you might have had your loan originate in one fiscal year and your forgiveness will be in another. I'm going to talk about, covenant calculations and those sorts of things, but, you can't record, in my opinion, GAAP is not going to allow you to record a forgiveness before it's certain. Certainly you can disclose it and you can count on it in your forecasting and things like that, but that's going to be a tricky thing to talk to your accountant and auditor with. Next slide on some banking issues. So most credit agreements that I read and review, have restrictions on the borrower going out and getting new loans and debt without permission. So when you got your PPP loan, did you just blow your covenant with your bank? If you got your loan through, your current relationship, does that count as permission, or did you have to formally ask? If you went out and got a PPP loan from a bank that you don't have a relationship with, now what situation are you in? So, it may not be a problem, but something to pay attention to. Covenant calculations, like I said, this is debt until it's for sure forgiven. You got to record that and include those aspects in your covenant calculation. So you got your leverage, fixed charge, might have tangible net worth, calculations, those are all going to be impacted by, this new debt. Are you going to be able to include your forgiveness in your income, for your covenant calculations? And then, there's a whole slew of different reasons that you might have, trailing 12-month or trailing 4-quarter calculations that are going on, whether it's for earnouts or, bonus calculations for banks, for employees, what have you. And so there's a whole lot of nuance there in how these things are treated. And, you don't want to wait until the end of the rainbow, to be thinking about them and talking to the constituents that are involved. Next slide, some more issues. One of the things is, again, as I've looked at these loans documents and the picture there that starts with number 11, this is actually a screenshot from a loan document. And a lot of people aren't noticing this, but, it says before the signature line, by signing below, each individual or entity becomes obligated under this note as borrower, capital B. Capital B, borrower, is a defined term within these loan agreements. Capital B, borrower, in these agreements are joint and severally liable. They're, providing a guarantee of these loans. So if I'm Joe, accounting manager, Joe, CFO, is not an owner of a business, and I signed off on these loan documents, what did I just do? Is this going to be a problem for individuals? Is this going to cause, cross defaults between entities where one entity is, signed up and now they're capital B borrower on other debt. And, there's all sorts of, spider web of things that depending on who put their name or what entities have their names on those loans, that could have been created, need to be unwound. I think that generally, there's going to be a lot of grace in this area, and I'm not going to pretend to understand why a lot of these documents have, this in there, whether it's, at the guidance of SBA or whether it's the banks. Everyone that I've seen has it in there. So I tend to think that it's not the banks putting it in there. But again, these are things that, you don't want to wait till the end to think about and look at. And if you're about to sign one of these, you might want to inquire and think about what this means, for you and the entity. Auditor issues on the next slide with the PPP loans. Again, we talked about a lot of these issues. Debt covenants, are going to be asked about, in these other items, not necessarily related to, the triple P items, but you're most likely going to have more significant going concern discussions and analysis with your auditors than you might have otherwise. There's certainly going to be, a lot of subsequent events potentially that were either disclosed in the 2019 audit, or if you're a June 30 year end, there'll be a lot of things that, might not normally be in there that will be. So, all those things are, important to think about. If you happen to be a C Corp, your tax provisions are going to look and feel a lot different. A lot of things that Andy talked about are good things. So this doesn't apply to a whole lot of people, but something to pay attention to, as well. If you happen to be a C Corp and have a tax provision. All right, so the next, and I went through that very quickly in high level. If anyone has follow-up questions, please don't hesitate to call me or send me an email. The next section here is just a quick high-level M&A update. So I'm starting on PDF page 63. The first slide here, I don't think anybody's going to be shocked to to hear that the M&A environment has slowed down. If I told you the opposite, I think you would have been shocked and called me crazy. So of course deals have gone down, dollars have decreased, and that's there's three primary things related to that. One is that logistically commerce was just closed and you couldn't meet with people, and that has a real impact on on deals, getting to know management, making site visits and those sorts of things. That's a real problem for getting certain deals done. The other things are that a lot of strategic buyers who were really M&A focused now are diverting assets and resources to managing this crisis, whether it's taking operations remotely or managing cash flows or employees or whatever the case may be. So there's just resources are diverted to that. And then similarly with financial buyers, a lot of them are in full portfolio management mode, and so they're helping their portfolio companies weather the storm, and that's obviously taking a lot of energy and resources away from going out and searching for deals. But our opinion is that once we get closer to normalcy, and I'm not going to pretend to know when that is or what that will look like, but that this market is going to come back very strong the way it was before the pandemic started, because there's still a lot of companies out there that need to go through exit planning. This may actually batter some owners into wanting to be done, having gone through this, wanting to sell and be part of a larger organization with more resources and things like that. So we are bullish on what this means going forward. The next slide has some information here, and I apologize for this was meant in a PowerPoint, not PDF, with some of the formatting, but the information is there, just some information there on how the deal process is being impacted. One of the things that's interesting that we've seen is that, there's a lot of creativity in the market going on, especially as it relates to products, and especially insurance products related to reps and warranties insurance. There's product tax insurance that you can buy specific to certain tax issues that a seller and buyer may not be able to sufficiently quantify and agree upon how to value that risk with one another, and so it's a barrier to a deal happening. But if you're able to introduce an insurance product into the mix, then you can instantly quantify that through the cost and reduce that risk. The other thing, as a lot of people ask, well, what's the benefit of having an investment banker as part of your team, or what's the importance of having a deal savvy attorney as part of your advisory team for a transaction? Well, it's for exactly these waters that we're about to wade into, whether it's these issues I'm talking about with reps and warranties, or whether it's negotiating the valuation. We feel the market is going to accept add backs related to this period, because it's impacting everyone. Certainly no one has control over what's going on, and it was next to impossible to be able to predict these things and have them as part of your contingency planning in your business. So we believe there's going to be ample opportunity for add backs, but if you don't have the experienced investment banker and deal team surrounding you, you're going to really struggle going through some of these things. So it just highlights the issues here of having that experienced deal team as part of your advisory crew. And that goes for before and after. When you're planning for an exit or transaction, and also during, you can't just call everybody to the table the day you want to go to market. There's a lot of pre-work that needs to go into that as well. So the next slide, as far as what's next, another reason that we're bullish on where this market is going to go on the go forward is that one, we think the valuations are going to normalize once we get back to there, and that there's, like I said, there's creative structures that are going on that are going to be able to get around some of the risks that people are going to feel. The other thing, and this is not even an opinion, that there's still almost $2 trillion of dry powder out there waiting to be deployed. I probably get a phone call or email 2 or 3 times a day from private equity or other folks that are out there looking for deals right now. So there's no lack of desire, to jump in. It's just going to be, when do the logistics come back online? When are things open back up? And, there's going to be transactions, once again. And like I said, these are uncertain times, and having somebody at the table that has been there and done that is going to be, critically important. And then our very last slide, there's just some key deal terms that, we have in there. Certainly on the go forward, there's going to be, buyers are going to be focused on less cash and having earnouts and holdbacks, and so it's going to be a real battle, throughout the whole process, even in the LOI negotiation stage, where it might not have been as much prior. People are going to want to get these issues out on the table sooner than later. So, those are all going to be key things, to focus on as we go forward. All right, and with that, appreciate everybody listening. I'm going to kick it back now to Albert, and we'll see if there's any questions from the audience out there.
Thank you, Tom, very much. We do have a large volume of questions. We're going to address some of them that we think we have some general interest in. We apologize if we don't get to yours. I'll just kick things off, and I'll throw out the question. If appropriate, I'll give you my 2 cents and see if my fellow panelists have anything to add. The one question we got was, is it legal to make a change to a PTO policy while employees are furloughed due to COVID-19? So first of all, I want to reiterate the prior disclaimer. When it comes to things like PTO policies, these are typically called welfare benefit plans. Those issues are regulated very deeply at the state level, so it depends on what state you're in. There can be markedly different laws that relate to that. So I'll give you the general principles. And the general principles are that things like PTO policies can be changed with a couple caveats. One, you have to do it prospectively. And 2, it can't divest or divest someone from something that is deemed to have been earned. So vacations, PTO policies, depending on how they're written, can oftentimes communicate to an employee that if you do this, like if you work this long or work this many days or have this many hours, you get this PTO, you've earned it, it's vested, all the words that are synonymous with it. And when that happens, a lot of state laws kick in, because once something is defined by you, the employer, as earned, it can turn into something that state laws look at the same as they look at wages, which are earned. And once that happens, paycheck security laws, wage payment and collection laws can kick in. So that's a long way of saying is you can generally change your PTO policy, but you got to be careful to do it prospectively and not do it in a way that robs someone of something that they have already earned. One example of this I mentioned earlier is if you're worried on a foregoing basis about people using PTO in a way that made sense when we weren't dealing with coronavirus, but now it doesn't make sense since the year effectively is compressed and people are coming back to work. You do have some leeway in most states to change that, because just changing that isn't taking money out of people's pockets or things that people already earned, and you're looking at it prospectively. If anybody else among the speakers has any comments, feel free to jump in. I'll take that as a resounding no and move to the next one. I also get a question here that says, I hear from a number of business owners concerned about starting back up and the employees or customers contracting coronavirus at their place of business. The concern is the litigation risk related to those who may contract COVID-19 at their place of business. What advice do you have? Or is there any pending legislation to help limit this overall risk? That's a great question, common question. And the answer is yes. There is a lot of debate as to whether or not Congress or other legislative institutions, including state congresses, should step in and give, in effect, waivers for businesses so that they can't be sued or can limit or mitigate their risk to customers, the public, who may claim that they contracted COVID-19 in your business. And in terms of employees, that's more difficult. Employee, illnesses or injuries are covered by workers' comp laws. These are, again, state-specific. But the thing that runs common through state-specific workers' comp is this notion of no fault. So most workers' comp programs are designed to be a separate legal system, a separate jurisprudence for handling injuries and illnesses when they're contracted by employees or suffered by employees. So it's handled very differently than if a claim is made by a customer. Workers' comp laws are designed as part of their DNA to be kind of no fault. They're designed to be sympathetic and humane with respect to erring on the side of protecting employees. So when it comes to the employee side, there's a lot less debate about limiting liability for businesses. I think the solace that businesses can take is that it's typically workers' comp limited. So it's while it's no fault, it's capped damages. There's civil immunity in most states, so the only recourse an employee would have would be through the workers' comp, which is much more structured in terms of things like damages, doesn't typically include pain and suffering or the things that can kind of drive the risk management side crazy. But on the customer side, that is very much an open question. There's lots of debate in Washington, D.C. and every state legislature about the extent to which they should do that to give businesses some certainty. My guess is that our insurance friends on the call may have some comments on that, and I'll give them a couple seconds here to chime in if they do.
Actually, Albert, I think that covered it pretty well. I mean, it's going to be, there's going to be a lot of potential pitfalls, but no, you captured it pretty well, actually.
Well, thanks. I'll move on to the next one if no one has anything else to add on that. The next one I have is, do we have to offer those employees who walked off the job after we received their waiver to stay open a return to work? I'll speak again more generally. One of the things I've been telling clients for a long time is to understand the difference between the folks who aren't working for you anymore as a result of the coronavirus. If you've separated from them employment-wise, so if the action that you took was to end their employment, then they're no longer employees, and there are generally fewer issues related to them. You can certainly call them out of the blue or reach out to them to see if they want to reestablish that employment relationship. But most employment laws axiomatically apply only to employment relationships. So things like callback rights, things like the tangible job actions that you take for employees are more often in the situation where you had someone stop working, but you didn't end the employment relationship. So the vernaculars that we typically use are things like layoffs and furloughs, which mean you're not working, you're not getting paid, but your employment hasn't ended. But all that having been said, if someone took an action like they walked off, usually it's appropriate for employers to take that into account if they're trying to make a decision on whether to call someone back. But again, I go back to my earlier comment, is what you generally want to do is to be motivated solely by legitimate business reasons. I'll just add one more thing before I see if anybody else wants to chime in. There has been federal guidance on, for example, the PPP loan side on if you call someone back and they don't accept, that will be not a negative impact on your PPP loan forgiveness. So there's certainly a lot of discussion out there about people who have separated in some way from you or been laid off, your attempts to bring them back or not bring them back, and what consequences are. And each of those situations can be complex and specific. So I've addressed it generally. Does anybody have anything to add on that? I'll move on to the next question then. And the next series of questions are all PPP related. I'll just say before I deal with a specific question, I'll say that I'm extremely sympathetic and empathetic with borrowers, PPP borrowers. This is an extremely complex law. The CARES Act was 880 pages. The PPP loan is a very different kind of animal. It's different to typical SBA sponsors loans. And there has been some guidance, but not a lot. There has been missing guidance on some key parts. So unfortunately, there's not a lot of certainty on some very key parts. Just this week, there was some activity relating to, I guess, the first of what I would call the three stages of PPP. So the first issue is, should you have applied? And if you did, should you keep it? The second stage is, once you've decided to apply and keep it, how should you spend it? And the third stage is, once you applied, got it, and spent it, what should you do to maximize the forgiveness? So this week we saw little guidance, particularly with respect to borrowers of less than $2 million. On the first side, gave a lot of comfort to small borrowers that there'd be a presumption that you had an adequate need for it if you had less than $2 million. There's not a lot of guidance for larger borrowers in terms of what standards or what yardstick you'll be measured against in terms of the decision to apply and keep it. So that's still up in the air. There's still a lot of open questions on the second and third pieces. So there has been some statutory language and some guidance on what you can spend the money on. I think most of us have heard that. You can spend the money on payroll costs, quote unquote. You can spend the money on non-payroll costs, which are things like utilities, mortgage loan interest, or rent. There's been language that I mentioned about that. There's not been a lot of specific guidance on exactly what that means. So one of the questions we got is workers' comp insurance included in payroll costs? If you read what's been out so far, and with the obvious caveat that we could get regulation that clarifies it, if you read what's out so far, the answer is no. Payroll costs have been defined very specifically as salary, wages, and so forth, employee benefits, including cost for vacation, parental, family medical leave, state and local taxes assessed on compensation, and then non-payroll costs are, as I mentioned before, interest on mortgage obligations, rent, and utilities. So if you take the construction of what's been issued out there, a workers' comp insurance premium doesn't seem to fit in any of those buckets. But again, we're waiting on some clarity on the spending piece of it, and hopefully we'll get some. Does anybody, including my
Albert,
accounting friends, want to chime in there?
Hey, Albert, it's Will. So I just wanted to add one thing with respect to the workers' comp. We have been getting questions about how insurance carriers are going to handle auditing the payrolls at the end of the policy term if we've been paying employees to basically stay away from their place of employment. So if we've been paying employees to stay at home, and what that's going to do from an audit perspective. So that's still evolving. Obviously, the carriers have to follow the guidance from the individual states, but from what we're hearing, there's going to be flexibility with the ability to reclassify employees. Let's say they're carpentry employees working for a general contractor, reclassify them as telecommuters, which would result in a lower rate. So if you're an employer that has employees that have shifted job duties, I guess the key would be that, it's going to be subjective based on your carrier and your state and what exactly the guidelines have been for their, what they've been doing in terms of their employment. But the key would be when you get to your year-end audit, if you're waiting till that point to make adjustments, be cognizant of the fact that there's probably going to be some flexibility there, and you can take advantage of that flexibility now if you're already in that situation. A lot of carriers are willing to make accommodations so that you aren't paying that premium for them to sit on it for the entire year. So definitely be engaging with your carrier and your broker on that.
Great, thanks, Will. Anybody else have anything to add on some of the PPP stuff we touched on? Another question I got about the PPP was transportation, that if you look at the definition of payroll, non-payroll costs, it talks about utilities. In that discussion, it mentions the word transportation. So there have been some questions about that. There's not been a lot of guidance. There's the only hint of guidance mentioned that idea of transportation may include, for example, gas on business vehicles, but that's one piece that unfortunately still has to be clarified quite a bit. Any comments or questions?
The only thing I'll add, Albert, this is Tom, is that we've, as a firm, have done a lot of, we did some prior webinars that are on our website on all these things, which have definitely evolved. But on any of these really granular, I don't want to call them accounting questions, but any of these questions, we've developed, a lot of almost a flow chart, a decision tree on some of this stuff. So if there's anything that anybody is feeling unanswered, feel free to reach out to Andy or I, separate, and we can help you out.
Okay, thanks, Tom. I want to be very respectful of every time. We have about 2.5 minutes left. I'll take one last question and we can call it a day. The last question is, there's a lot of discussion around employment-related lawsuits, but is there a greater concern or a concern surrounding IT and data security with more remote work during the crisis? And I know, Will, your clients come to you with data security and other risk issues. Is that something you have any advice on?
Yeah, we've definitely seen an increase in claim frequency in our agency, but the market as a whole. I think ransomware attacks have gone up over 600% since this began. So most of the attacks and most of the damage that they're projecting is going to be first party. So expenses and business income losses that you as the client sustain, not as much liability. Obviously liability is still out there, but I think that the big loss drivers are going to be business interruption loss because, so many businesses are allowing employees to work remote and significantly more dependent on their networks than they've ever been before. So, what does that do if your network goes down due to a breach from a business income loss standpoint? That will be very significant. And that's not it is driven by COVID, but it's not like property business interruption where there's typically not an insurance response for it. That would be a coverable event in most situations. The other thing that you want to be aware of is what's your carrier's definition of your network when it comes to disruption. So, a lot of companies have had to get liberal with how they allow employees to access the network, and with bring your own device policies going into effect, if there's system damage, how's your carrier going to respond to actual system damage to property that's not yours, that's your employee's personal computer, let's say, and their VPN usage, that sort of thing. And then I think ransomware is going to continue to be a big threat. Cyber extortion, employees being at home, more relaxed environments, not maybe as positive as they normally would be about scam emails. You definitely need to be sure that you're relaying to your employees, especially if they're working remote, that they need to be hyper vigilant because we are seeing the claim frequency go up through this crisis.
Okay, that brings us to 1:30. Thank you, Will Collins, for the answer to that question and for participating on our panel today. I also want to thank the other panelists, Jim Fawcett, Tom Gray, and Andy Bianco. Thank you also to Allison and Benny Umpkins who helped support this, and most of all, thank all of you for spending some of your time with us today. We appreciate it, and we wish you all a healthy and safe time through this crazy situation. Thank you.